I hope I am audible now.
Audible, sir. Audible.
I had a really difficult time joining the session. I'm extremely sorry for being late in joining the session. Good morning, everyone. Uh, I'm not sure whether my network will last for 2 hours. So as long as I'm here, let me try to finish as much as I can. Okay, let me see if I'm able to share my document. Okay, now the document is visible to all of us, right?
Yes, sir.
Yes, sir. It's visible.
And I'm also audible. I hope nothing bad happens to the session anymore, because I've been trying to join the session for last 30 minutes and there was some issue or the other. Right, so I have been given the task to talk about two things. One is intellectual property and the other is innovation. Innovation is not my subject. Intellectual property is my subject, but I'll try to connect these two. And I'll go really slow and I'll be talking about very basic things. However, I understand that you are familiar with the idea of innovation. You have been doing the course for last 4 days. So my job is not to go in detail of this second word, innovation. I'll be emphasizing more on the importance of intellectual property for innovators. So let's start. People from management studies will tell us that business has only two functions to perform: marketing and innovation. And according to management students, only these two produce results, all the rest are costs. I understand innovation as something which means commercialization of new ideas, while invention is not directly associated with commercialization. Right? And in intellectual property laws, patent law particularly, we don't use the word innovation, we use the word invention. Invention is generation of ideas which are aimed at solving specific technical problem, whereas innovation is commercialization of new ideas. We know that all inventions are not commercialized. I'll tell you in my later part of the discussion that hardly 3 to 5% patents are revenue generating patents. So approximately 3 to 5% inventions are commercialized. So therefore, not all inventions result in innovation. Many inventions, many ideas never see the light of commercial success. These die a lonely death. And there lies the importance of various tools of intellectual property, which facilitates the process of movement of invention from lab to marketplace. Innovation may mean one of these two. It can mean offering new commercially viable products or services, or it may mean offering more efficient ways of doing things. Improvement innovation. Now, in case of improvement innovation, it can be in the form of using new raw material, maybe, or maybe in the form of using a better production process, which makes it possible for us to make those products in a faster way, in a better way, or maybe in a more cheaper way. As I said, I will not be talking about innovation much. I will try to see as to how intellectual property plays a role in different stages of innovation. You can see I have identified 4 stages, and the activities performed during these 4 stages are different. So therefore, IP considerations during these 4 stages will also be different. These stages are conception of innovative ideas, then comes the stage of research and development, R&D stage. Then you have commercialization and marketing of the products or services. As I said, my job is to tell you which form of IP is more relevant for a particular stage of innovation. What IP concepts more important in conception of ideas? What IP considerations are more important in R&D stage? And what IPs are more important in commercialization and marketing of the products and services? But before we understand the importance of IP in these four stages, let's first of all broadly understand the meaning and kinds of intellectual property. I hope this broad understanding of meaning and kinds of intellectual property will help us in understanding the relationship between IP and innovation better. Because I don't know the nature of audience, I go on the presumption that many of us may not be studying IP on regular basis. Intellectual property laws regulate creation, use, and exploitation of intellectual property. And what is intellectual property? It is creation of your intellectual faculty. These are intangible. These are different from physical property. You see, it is really simple to locate a physical property. Even if I do not have an address of my building or my house, still I can tell you where you have to come. But the biggest problem in intellectual property laws is locating the subject matter. You have many legislations, many laws which deal with IP, from Patent Act, trademarks, and copyright, then plant variety law, industrial designs law, and so on and so forth. All these IP legislations, first of all, identify the subject matter. For example, if we talk about Trademarks Act, mark is the subject matter of Trademark Act. But not any mark will become intellectual property. A mark which is used in the course of trade becomes intellectual property when it has got a property called as distinctiveness. That mark must be able to distinguish goods and services of one trader from the goods and services of other traders. So not any mark will become the subject matter of trademarks law. Not any mark will become an intellectual property. Only that mark which has the ability to distinguish goods and services of one trader from goods and services of other trader, that becomes an intellectual property. Similarly, inventions form the subject matter of Patent Act. But not all inventions will qualify to be called as intellectual property. Under patent law, only those inventions which are new, which have an inventive step, meaning thereby which are not obvious to a person of that discipline, and which has got applicability in industry. Only such inventions may be called as intellectual property according to Patent Act. Under copyright law, the subject matter for protection is work. Work can be literary work, anything written, printed. It can be artistic work, drawing, painting, engraving, etc. It can be musical work, any music. It can be a dramatic work. These works are the subject matter of copyright law. But not all works will get protection here. Only those works which are original will get protection under copyright law and may be called as intellectual property. In a similar fashion, other IP laws also provide certain keywords with respect to which the subject matter is identified. Intellectual property can be broadly classified into two parts. One is industrial property, the other is copyright. Industrial property will include all other forms of IPR except copyright: trademark, patent, industrial designs, semiconductor integrated circuit layout design, new varieties of plant. There are many other forms. All these forms are called as industrial property. And the other category is copyright. This is a 100 years old classification. This classification was done when there was an understanding that copyright has nothing to do with industry. When we used to think that copyright has to do with art, literature, and culture, it has no role in industry. But that understanding is not relevant anymore, because you all understand that today, entire music industry, entire cinema industry, entire broadcasting industry, the software industry, these all are governed by copyright law. And therefore, in 2016, by way of new IPR policy, government shifted the administration of copyright to Ministry of Commerce. Prior to 2016 policy, the administration of copyright was in the hands of Ministry of Education, Ministry of HRD at that time. Now, this classification is not relevant anymore because all the forms of IP have connection with industry. We all know imagination is more powerful than knowledge. And intellectual property is based on power of imagination. As we study the subject, we realize that intellectual property is a force that can be used to enrich the lives of individuals and future of nation, materially, socially, culturally. IP stimulates economic growth. You come across a problem, the first thing you do is acquisition of knowledge, which leads to imagination, followed by innovation, which creates an IP solution to that technical problem. We know that we are living in knowledge economy, where the traditional determinants of wealth creation, that is land, labor, and capital, are not very important. It is the way you create and manage your knowledge that decides your competitive edge. Globalization has fueled tremendous competition in marketplace. With the advent of WTO, every single enterprise has to face competition, locally and internationally. And in this competition age, Indian startups, Indian small-scale industries do not know the best mode to manage their knowledge resources, knowledge assets. This is the context in which I am talking about importance of IP in relation to innovation. Imagine a small-scale industry, the total physical worth of that small-scale industry maybe 10 crores. Will that small-scale industry with total physical worth of 10 crores will be able to generate loan more than its physical worth? Will that small-scale industry be able to get partners who are doing business when the total physical worth is around 10 crores only? There comes the importance of intangible assets. The intangible portfolio, the IP portfolio, will help that small-scale industry to generate loan, to get partners in doing business. There are hundreds of examples where we can see that small industries growing into big MNCs with the help of efficient management of intellectual property. Pliva, a Croatian drug manufacturing company, was very close to closure during 2000, 2001. They invented a drug and obtained patent in Europe and in other countries. But they were a small enterprise, there was a small company, and they did not have means to commercially exploit the invention. When scientists of Pfizer were going through the catalog of American Patent Office, they found this invention and they obtained license from Pliva. The drug is called azithromycin. It was a very successful antibiotic. Pfizer introduced that drug with the name Zitromax, and only in 2001 the drug could raise a revenue of 1.5 billion US dollars. That changed the fortune for Pliva. One single patent converted a small enterprise into a big pharma giant. Intellectual property protection is a sine qua non, is a mandatory requirement for economic and technological development of a country. IP creates property right over knowledge. Intellectual property may be defined as set of exclusive rights which are granted by the state over the IP, by which others are excluded from commercially exploiting the property. Patent, for example, is an agreement between the
Excuse me, sir.
inventor. Yes.
Sir, I had a doubt. Can I ask in between or can I ask later?
Both ways, if you want to raise it, put something.
Yes, sir. So, sir, I was intrigued by the point which you made that intellectual property rights, they basically fuel economic growth, while the innovation, it fuels the whole innovative culture or the startup culture. So, can you kindly provide some more depth into that?
As I said, fine. As I said, innovation is to do with commercialization of new ideas, where invention necessarily is not connected with commercialization aspect. For me, the important word is invention, because in patent law, the word used is not innovation, it is invention. Innovation is definitely invention plus something else. That other aspects are not part of intellectual property law. What I was trying to tell you is that IP protection induces someone to invest in the process of invention. Because intellectual property creates monopoly in favor of creator, because IP law ensures that nobody will misappropriate your property, because IP laws give you protection against free riding, because IP laws create exclusivity in your favor, you are encouraged to enter into enterprises which are risky enterprises. You are encouraged to invest your time, capital, and skill in activity which otherwise you would not have taken up. So technological development has connection with the monopoly rights which are granted by intellectual property. Why would I invent if I know that others will also be allowed to manufacture and sell it at the same time? That is how IP will promote technological development of the country. That is how IP will promote the economic development of the country. These rights create a zone of exclusivity for a limited duration of period. During that period, only the owner of rights can exploit the intellectual property. You see, by providing a fair degree of exclusivity over the exploitation of innovation, the system of IP rights create an incentive to invest in scientific technological activities. IP system reduces the risk of free riding. Others will not be allowed to commercially exploit your invention. As I said, various stages of innovation will have to do with various forms of IP. Different kinds of IP perform different functions.
Excuse me, sir.
Yes.
Sir, taking the cue from the discussion, like you said, innovation is invention plus something. So this something can be, we can take it to be the legal compliances or the protection, the IP protection.
I think invention itself is the word which we use in legal realm.
Okay, sir.
In legal documents, we use the word invention in place of innovation.
Okay, sir.
But as I said, those inventions which become viable inventions, which become commercially viable inventions, and those inventions which successfully reach to market, they may be part of innovation.
Okay.
Or
So
you
the
can say innovation is the process of product development,
okay, sir.
where invention is the content of that product which precedes maybe the ultimate stage of product development. As I said, my word will be invention, because the word which we use in patent law is invention, not innovation. And you will
Got it, sir.
learn about this more. Let me go through some of the slides. Maybe you will learn more about it. So different kinds of intellectual property perform different functions. Let me rush through meaning of all these forms of intellectual property. Now, before I proceed, kindly tell me, is it fine? Do you understand whatever I am saying? Am I making sense to you? मुझे बता दीजिए जल्दी जल्दी.
Yes, sir.
Yes, sir.
Okay. Let's go step by step. Let us understand meaning of all these forms of intellectual property. A patent is an agreement between inventor and the patent office, by which the patent office grants exclusive rights to inventors for 20 years, and in return the inventor is asked to disclose his invention. Invention has to be new. It must not be obvious to a person who is skilled in that art, and it must have some industrial applicability. The patents are limited monopoly granted by the patent office to the inventor. Why I am saying limited monopoly? Because it is granted for 20 years from the date of filing of application. And in return, the inventor has to disclose his invention in a manner so that any skilled person, after reading the disclosure, can perform the invention. The second is trademark. As I already said, trademark is a mark which we use in the course of trade to distinguish goods and services of one trader from the goods and services of other traders. A mark must have distinctiveness in order to get protection under trademark law. The third one is industrial design. Industrial design means any design which is made on the object, on the article. You must have seen school bags of small children, you must have seen water bottles, you must have seen biscuits. All these goods come with certain patterns, certain design on the goods. So any pattern which is part of the goods, which appeals to your eye, which adds aesthetic value to the goods, are protected under industrial design. Textile industry, carpet industry is to a great extent regulated by Designs Act of 2000. The difference between industrial design and trademark is marks are used on packaging, designs, industrial designs are part of the goods. The next one is copyright. It gives a legal protection to authors, owners of literary work, artistic work, dramatic work, musical work. Literary work means anything which is written, printed. Computer programs are part of literary work. So computer programs get protection as literary work under Copyright Act. The next one is related rights. These are also called as neighboring rights. These rights get place in copyright law itself, but these are not given to owners of literary work, artistic work, dramatic work, and musical work. These are granted to performers. Somebody who is making performance, including person delivering lecture, acrobat, juggler, snake charmer. So anybody making performance is an intellectual property creator and he gets protection under related rights. Related rights are also granted to producers of sound recording, T-Series, HMV. Related rights are granted to broadcasting organizations, Star, Sony, ESPN. They get rights on their radio and television programs. The next is a geographical indication. You must have heard about Pashmina shawl or basmati rice or Bhadohi carpet. These are geographical indications. These goods have certain property which they have got by virtue of either the manufacturing process prevalent in some area or the climatic conditions unique to that area. So all the people of that area are allowed to use that indication on the goods which they make. For example, Banarasi sari is a GI which can be used by weavers of 5 adjoining districts of Banaras. Champagne is a sparkling white wine which is manufactured in Champagne district of France. There are more than 20,000 families which are into making of champagne. You cannot have Spanish champagne because the word champagne can be used only by the people who are making sparkling white wine in the Champagne district of France. There is one more form of intellectual property which is not generally known, and we don't have a law to deal with this law, with this form of intellectual property.
Sorry to interrupt you, sir. I have one doubt. Shall I proceed, sir?
Yes.
Sir, the companies, organization, institute, all these logos are so protected with IP, sir?
Right. You see, if you are a trader, you can get your logo registered as a trademark. But if you are an institution which is not doing trade, you can still get protection under copyright law. I may
And
add one thing.
tagline also. Adding the one point tagline. All this tagline should be also with provision for IP, right, sir?
Right, yes. Let me finish. There are certain forms of IPR which give protection only once you register your intellectual property. For example, patent has to be granted by patent office, to be registered with trademark office. But copyright protection is automatic. Copyright springs into effect the moment you create the work. So you don't have to get your logo registered in Copyright Office to get protection. It is an artistic work and it will start getting protection from the date it is created, right? Including the tagline.
Sir,
Including the
just
tagline.
again, sir, before sir launching any logo, should you take any commercial approval from the concerned agency also? What you told regarding Ministry of Commerce, now it is handling. So is it also required from any industry for making any logo?
No,
Okay,
it
because
it is
sir,
an artist.
last year there was issues are going in Mintra logo. Earlier Mintra there is small type logo. Even they've changed the logo. There was some objection came from all this publics.
Sir,
They changed
sir.
the logo.
You have to keep it very clear that whether you are going to use your logo in the course of trade or are you an educational institution, if you are going to use it in the course of trade, you must get it registered under Trademarks Act to get the protection against misappropriation, so that nobody else can come with a similar mark, right? To stop others from using similar mark, you must get your mark registered in the Trademarks Act. And when you will go for registration, there are grounds like that it should not be scandalous, it should not hurt the sentiments of anyone. These grounds are also there to see before registration of your mark, right? So when we are talking about logos, we must first of all clarify whether it's a logo which belongs to a trader or whether it's a logo which belongs to an educational institution, for example. Right? Is it done, sir?
Yeah, correct, sir.
I was mentioning that other form of intellectual property which is not generally known, we don't have a statute for it, is trade secrets or undisclosed information or something which may be called as know-how. This is a very important form of IP. We don't have a law as of now, but then this is very important in some of the stages of innovation. See, every enterprise has to deal with IP. For example, if you develop a new product, it may be of new design, you will get protection under Designs Act 2000. There may be a brand name, it has to get protection under Trademarks Act 1999. You may have a website or to advertise the product, the website will get protection under Copyright Act. You may have a catchphrase or a distinctive jingle, that may get protection under Copyright Act. There may be technical drawings. Drawings are also artistic work, you will get protection under Copyright Act. The functional feature of the invention will get protection under Patent Act. So therefore, if you are a company who is launching a product, you have to deal with intellectual property in a significant way. I hope we understand some basic aspects of intellectual property, its kinds, meaning of IP, meaning of patent, meaning of trademark, copyright, industrial design, trade secrets, etc. So far, is there any other query? Now you
No, sir.
see, enterprises attach more importance to patents and trademarks in the context of their business. They claim patent on their new inventions and they promote those inventions under a certain trademark or brand name. And for them, these two are relatively more important. Importance of patent is visible if you look at the number of applications which are filed in India or in other countries. The emphasis, more and more emphasis on patents is because of certain factors, certain regions which I have listed here. The shift towards knowledge-based industries, making intangible assets as the source of competitive advantage for firms is one region. Outsourcing of manufacturing activities is a very important region. If I hold patent on an invention and I want to outsource the manufacturing process to subcontractors, I know that while manufacturing, they will get to know about the invention and they may misappropriate it. They may come out with certain generic versions. So therefore, before I outsource the manufacturing activity, I will first of all get patent protection so that nobody is allowed to misappropriate. There have been legislative changes at national level, international levels. With the advent of WTO, I may tell you, a new document internationally came into existence. TRIPS agreement, TRIPS, TRIPS agreement is part of WTO. We are a member of WTO, we are a member of TRIPS agreement. TRIPS requires us to have a strong IP law. TRIPS agreement requires all the countries to have strong IP protection. And therefore, we were obliged to modify our laws to make the laws TRIPS compliant. WTO became enforceable from 1st January 1995. We were granted a grace period of 10 years so as to comply the laws with TRIPS and WTO. So on 1st January 2005, my laws must be in accordance with WTO. On 1st January 2005, my laws must be in compliance with TRIPS agreement. So we had this 10 years of grace period, a developing country. During this period, what we did, we amended Patent Act thrice, Patent Amendment 1999, 2002, 2005. We came out with a new trademark law of 1999, a new Designs Act of year 2000, a new Plant Variety Law of 2001, a new Biological Diversity Act 2002. So we either amended existing laws or made new laws so as to fulfill our obligation towards WTO or TRIPS agreement. This led to expansion of patentable subject matters. New subject matters started getting patent protection. And in addition to it, now there is a surge in patenting among universities and public sector R&D institutions. You must have heard about National Innovation and Startup Policy 2019 for students and faculty. It's a framework for higher education institutions. This policy has been made to actively engage students, faculties, and staff in innovation and entrepreneurship related activities to create robust innovation and startup ecosystem across all higher education institutions. There is a full dedicated part on intellectual property acquisition in the policy. Now the government is emphasizing on public funded institutions claiming more and more intellectual property so that they can become self-dependent and generate revenue for themselves. I'm sure somebody will talk about the innovation and startup policy of 2009. So I will not go in that. But now there is an emphasis on patenting among universities. Although we have not started it in that significant way, but very soon universities will be under tremendous pressure to innovate and claim IP protection. You see, you are getting policies one after the other. Because of all these factors, the importance of patent is growing. Now let's see, as I said, there are 4 parts: innovation, then we had R&D stage, commercialization, marketing. Let's see what IP considerations are more important in these 4 stages. The first one is conception of innovative idea. Conception of innovative idea. Prior art searching and analysis is critically important part of this stage. Especially searching and analysis of patent literature, which contains a vast amount of information not available elsewhere. Let me tell you more about this point. Prior art search means what? Prior art may also be called as state of art, and it comprises of all matter, all information which is made available to public on the date of filing of an application. I'll tell you more about it. Suppose I have invented something. In order to get protection, I will have to file an application in Indian Patent Office. In simple terms, the date on which I filed my application is the priority date. Okay. The first date of filing of application is called as priority date. And please also keep in mind that there is nothing called as international patent. You cannot claim a patent which is good in all the countries. Patents are granted by national offices, and these patents are valid only within that country. So if you think that your invention has market in other countries also, you must file application in all possible countries. So it's a very costly affair. Invention requires a lot of investment. Getting patent for that invention is again very costly affair, because you'll be filing application in all those countries where you think that you are going to exploit your intellectual property or use your patent. So if I am filing my application in Indian Patent Office on 1st January 2022, then whatever information which is available to public on 1st January 2022 will be the prior art for my application. Any information anywhere in the world, it may have come through publications, it may have come through use, it may have come through oral communication, any material, any information, any language, anywhere in the world will constitute prior art. And when my invention is filed in patent office, the novelty of my invention is examined with respect to this prior art. It has to be an absolutely new invention. Nobody must have heard about it. Nobody must have read about it. Nobody must have used it in past. And this prior art, a major part of this prior art is contained in scientific papers, published documents, and patent literature. What do we mean by patent literature? All the granted patents till 1st January 2022, all the patents which have been granted, all the pending applications which have been published, these all are patent literature. Nowadays, patents are highly technical and legal documents. A granted patent will contain detailed description of the invention. It also contains the background of the invention. So therefore, patent documents, patent literature contains vast amount of information that may not be available elsewhere. And when you are in the stage of conception of idea, the most important thing is to study the prior art. And by studying the prior literature, patent literature, prior art, it is possible for you to know whether an invention is new or not, whether your invention, your idea is new or has it been patented by somebody or has it been published earlier. You will also understand whether your idea tomorrow will be a successful invention or not. You can decide whether to go on investing money in this idea or not. You will also learn about the inventions which your potential competitors may be holding, or the trend of technology at that relevant point of time. This all information can be obtained by examining the prior art, the patent literature. So at the stage of conception of idea, don't go ahead and start investing money on a venture which may eventually become a futile venture. Before investing money, before proceeding with the idea, it is wise to look into the prior art and patent literature to see whether your idea is a viable idea or not, whether it is already patented or whether it is open, whether it has got market for tomorrow or not. The first important thing is prior art search. And there are methods of searching patent literature. You have international classification that has to be practiced. From a vast ocean of patents, you can easily pinpoint the area which is relevant to your idea. Another point during this stage is trade secrets. You must keep your idea as trade secret. Don't disclose it to anybody. You have to keep it secret because you don't want to alert your competitors. Another reason may be that others may file the patent before you could file it. In India, the rule, or in all the countries, the rule under patent law is the person who is first in filing the application will get the patent, not the person who is first in inventing. You may have invented something, but if you are late in filing your application, you will not get patent protection. So therefore, keep it secret, because otherwise it will alert your competitors. Somebody else may patent it. Or there may be a situation that tomorrow your idea may not become a patentable invention. You were not successful in converting that idea into an invention which is fit to be patented under Patent Act 1970. Therefore, it is wise to keep it secret. In order to be called as a trade secret, there are certain requirements. In order to be qualified as trade secret, there are certain requirements. First, the information which you want to keep as trade secret must be documented. Oral communications cannot be trade secret. Access to that document is controlled. Not many people may have access to that document. And the information must have some value. And of course, it is kept secret. For example, your business plans, a manufacturing process, algorithms, software code, marketing information, client data. These may be called as trade secrets if these are documented, access is controlled, it has some value, and it is kept secret. So at the stage of innovation, it is really important that we must enter into a confidentiality agreement with everyone who may have access to your lab, who may have access to the prototypes, who may have access to your ideas. Your employees, your students, the suppliers, the collaborators, the subcontractors, who may have access to innovation or the lab in which you are working. Every such person must enter into a confidentiality agreement. And if I breach that confidentiality agreement, there must be consequences. I may be asked to pay compensation for any loss which may have occurred to the lab, which may have occurred to the innovator. This is true for various institute innovation councils, IICs, which we are establishing in various universities and institutions. IICs are working for innovation. These IICs must have an IPR policy, and confidentiality agreement must be an integral part of that IPR policy. So keeping something as trade secret is useful because you may not lose it to others. But keeping something secret is a difficult job. And trade secret has certain disadvantages also. Let me tell you one significant point here. If I invent something and file an application, no one else can invent the same. No one else can come to patent office and file a similar invention or an application for a similar invention and say that, look, I have invented on my own. I have not copied. The similarity is not because of copying. These arguments are not acceptable. Once patented, no one else can come to that result, even if he has done it by his independent efforts. The protection under Patent Act is very strong. Once patented, no one can come to that result. But in trade secrets law, we do not have a similar protection. Although we don't have an act in India, but in other countries, under trade secret law, we do not have a similar protection. That means I have invented something, I have kept it a trade secret, a confidential information. You also invent the same if you can prove that it is your independent creation. I cannot stop you from manufacturing and selling your invention. So there is no protection against independent creation. Second disadvantage is if there is slight mistake and it leads to public disclosure. If there is a slight omission and the information comes to public domain, then tomorrow you yourself will not be allowed to claim patent on your invention, because now the information has come to public domain, it has become part of prior art. Keeping trade secrets is an increasingly difficult task in today's environment, where employees change companies regularly. Despite these disadvantages, one must keep every information secret as long as he is in the stage of conception of idea. Whether you want to get protection under patent law or whether you want to get protection under trade secrets law. Is it okay? Is my voice coming? Is it fine?
Yes, sir.
Okay. Whether you claim protection under ultimately for your invention, whether you claim protection for under patent law, or whether you keep it a trade secret, it depends on many considerations. Nature of invention is one such consideration. What do I mean by nature of invention? For example, if your invention relates to some drugs, you must not keep it trade secret. You must definitely obtain patent, because it can be easily reverse engineered. It is difficult to keep a drug invention secret. Invention in sectors where reverse engineering is not possible, there you can keep trade secrets. But as I said, whatever is the ultimate decision, at the stage of conception of idea, you must keep the information secret. So therefore, what I'm trying to say, during the stage of conception of innovative idea, two things are very important. One is prior art search, and the other is trade secret law. Further, during the stage of innovation, you may be making many technical drawings. Keep those drawings secret, because tomorrow when you will finally invent your product and when you will file your application for patent, these technical drawings will play an important role. So therefore, keep these technical drawings secret, because these technical drawings are artistic work also. So therefore, the moment you create these drawings, copyright protection automatically starts. But I advise everyone to date your creations. Put a date on your creation, or maybe mail it to yourself, because that helps in fixing the date of creation. And tomorrow, if the matter goes to court, you can prove that I was the creator of this drawing or diagram at this date. So all the technical drawings which you are making in the initial stage of conception of idea must be kept trade secret, because you are going to use these drawings at a later stage when you will file your patent application. All these drawings must be dated so that you can prove that you are the creator and you created the diagram on this particular date, because copyright protection starts the moment you create the artistic work. These are the IP considerations which are relevant for the first stage of conception of innovative idea. Now kindly let me know if it is okay for you, or do you have any query related to whatever we have discussed so far? Is it fine? Do you have any query?
Sir, I have one query.
Yes, please.
Like for the patent, if I am the inventor and my organization is the patentee, so the rights are equal for both the parties, or it is different?
Right. See, it applies in copyright, it applies in patents also. In patents, university cannot be a patentee on its own. University can be a patentee as an assignee of right to file application by the true inventor. So they cannot dismiss your role. Point number one. Because when the university files a patent application, when an institution files a patent application, it has to provide a copy of assignment deed, assignment contract. Institutions cannot innovate, right? An institution cannot invent. People like you and me will invent. So therefore, the true inventor can assign right to file application to the university, and then only university can claim patent protection. Point number one. Second, there can be a joint application. There can be a joint application filed by the true inventor and university as an assignee. Now, universities have the IP policy. Institutions have the IP policy. In US, they have a Bayh-Dole Act of 1987, which talks about university patenting. Now, the policy I was referring to, innovation and startup policy, that talks about revenue sharing. It provides you a broad model of revenue sharing and requires institutions and universities to frame their own IP policy. If you are inventing using the resources of university, you cannot be the sole applicant as part of university policy. It is not just a story of two parties. There may be a funding agency in addition to university and the inventor. In that case, all three may jointly hold the patent rights, right? And as far as sharing of benefits, sharing of revenue is concerned, it depends on the policy framed at the level of university, right? But because you are using the resources of university, you should not be the sole claimant. It has to be a joint application, and the revenue therefore shall be shared accordingly. Is it answered?
Yes, sir.
Okay.
Thanks, sir.
Now comes any other query? No. So therefore, in the first stage of innovation, prior art search, trade secrets are two important IP considerations. Then comes the stage of R&D. During the R&D stage, again, keeping the information as trade secret still remains relevant. And one must keep on searching the prior art. European Patent Office estimates that 70% of the information in patent documents is not available elsewhere. And with more than 8 lakh patents granted annually around the globe, they offer a wealth of information, such as information on the state of art. All these information can help an innovator in avoiding wastage of resources in terms of money, time during R&D process. During the R&D stage, you may get to know that lot has already been done by various people. Many information are already there in granted patents. So prior art search continues to remain a very relevant thing during the stage of R&D. All the granted patents, patent literature contain information which can be used to further innovate, further make improvements in the product. The patent literature is particularly important for small enterprises. Small enterprises in India are more into doing incremental inventions, making some changes and coming out with a new product. The utility of these incremental innovations depends on the way you conduct your prior art search. You get a lot of material which can be adapted to local conditions. And when you think that you have come out with your invention, by and large, it is advised that you must file your patent application during this stage. I may tell you that you are allowed a grace period of 12 months within which you can complete your invention and file a final application. Because the rule is that the person who is first in filing will get the patent, so therefore it is advised to file it during R&D stage once you think that you have by and large done your invention and you think that you will finalize things, fine-tune things within next 12 months, you must go ahead and file the patent application. And once a patent application is filed, the clock starts ticking. You have a sequence of strict deadlines. Your application will be published in these many days. Your application will be examined by examiner of patent within these days. Objections will be invited against your application within these many days. So strict deadlines will start. And you have to meet all these deadlines in order to keep your patent application alive. And therefore, you require some strategy before you file a patent application. It should not be too early. If you file it too early, there may not be sufficient invention in the application. If you file it too early, you may not be able to prove that your invention passes the requirement of inventive step and therefore eligible to get protection. At the same time, your application must not be delayed. It should not be too late, because your competitor may beat you in filing an application. So therefore, you need to have a strategy when to file the application. Because the rule is first to file rule. One who is first in filing will get the patent. So during the R&D stage of innovation, one must be very clear when he wants to file the application. And he must keep those deadlines fulfilled so as to keep his application alive. This is the stage when you will be using inventions which belong to others also. You see, it's not an absolutely new invention. You will rely on existing inventions, you will rely on existing knowledge to some extent. So during R&D stage, you will also evaluate the risk of infringement, whether I am violating others' patent rights. How to avoid violating others' rights? Or should I challenge others' patent? It is possible for someone to file an application for getting somebody's patent revoked. So during R&D stage, if you come to a conclusion that a patent has been wrongly granted to a third party, it should not have been granted, so that you can use part of that knowledge in your invention. In that case, you can take a decision to file a revocation application against the third party. During the R&D stage, one very important aspect to be taken into account is design registration. Patent takes long time for registration, 2.5 years to 3 years maybe. Startups need to develop fast in order to become viable as soon as possible. So if they rely on patent alone, it will be difficult for these startups to become viable. So apart from patenting, they must also think about design innovation. Apart from claiming protection on functional features through patent, they must also think about getting protection on aesthetic aspects through design registration. I already said that design registration, design is something which is used on the article. It has nothing to do with functionality to be achieved. It only relates to aesthetic aspect. It only appeals to your eye. The design in the finished article appealed to and judged solely by the eye. So apart from patents, the innovator can also think about design innovation and think about registration of design. So this is what you have to follow during the R&D stage. There are 2 more stages left. These are not that relevant for innovation purpose. However, I briefly talk about these 2. We understand that the aim of business organization is to maintain market share, expand market share, create new market. IPRs create exclusivity. Only I can use it for 20 years. So it will deter others from entering into the market. Others cannot enter into the market for those 20 years. And therefore, companies with IPR have strong market position. And therefore, IP can contribute to accomplish the purpose of marketing. Not just an asset, it's a tool. There is an important observation. You get an exclusive 20 years to market your product, to sell your product. No one else can sell that product for 20 long years. Now what happens? You get these 20 years not only to market your product exclusively, you get 20 years to establish your brand exclusively in an environment free of competition. And therefore, in most of the cases, even after expiry of those 20 years, people prefer to buy the same branded product. It happened with azithromycin, the drug which I mentioned. The brand used by Pfizer was Zitromax. The patent duration expired in 2006. People still continued to purchase Zitromax. There was very small decrease in market share of Zitromax, although there were many generic versions, because once the patent duration is over, anyone and everyone will make that product. So many generic versions came in market after 2006. Still, people prefer to purchase Zitromax, because Zitromax had the advantage to grow the brand presence in an environment free of competition. The role of IP depends on many factors. In commercialization stage, the role of intellectual property depends on many factors. Business model, for example, patents, trade secrets are more important for technology companies. Trademark is more important for consumer brand sector. So it depends on business model, which IP is more important for you. It depends on the market, length of product cycle, etc. The most important thing is it depends on the stage of business evolution. The role of IP will depend on the stage of your business. The role of IPRs will become more sophisticated as your business grows. So apart from innovators, even managers need to have IP awareness. Because I can tell you that intellectual property is a poorly managed asset in India and Indian companies. It is considered as something which belongs to legal people. It's a legal matter, which is a wrong understanding. It's a strategic issue. We underestimate the value of intellectual property. The focus of business mostly is on short-term results. Therefore, IP assets are poorly managed. And as I said, apart from innovators, even managers need to have IP awareness. This is your IP value chain. It is visible on your screen, I think. You have an idea, an innovation which leads to product. This product is protected by filing an IP application. Then your intellectual property protection is granted to you. Once patent is granted, every year you have to pay patent maintenance fee to keep your patent alive. If you do not pay patent maintenance fee, your patent will lapse, and it's a significant amount. So you are paying a lot of money in maintaining your patent. This part is portfolio management, from IP filing to IP management. Then comes the stage of commercialization, when you determine the value of your invention and you license your invention to third party for manufacturing and selling. As I said, IP maintenance is a costly affair, and you have to be very careful on this aspect. There is a company known as Dow Chemicals, DOW. Dow Chemicals owned approximately 29,000 patents, many having little commercial value. An audit was done, and they abandoned their non-core patents, and they could save $40 million only in the form of patent maintenance fee alone. This is particularly important for an individual innovator or a small enterprises. If they innovate, if they invent something which has limited commercial value, then they'll be maintaining it without getting their invention commercially exploited. And they will be draining out their resources for nothing. So therefore, portfolio management is important. And there are two words which I have used. You can see IP valuation and IP auditing. These are important aspects of management of intellectual property. These are good not only for enterprises, these are good for any innovator. And these are particularly important for small scale industry. You need to know the stage of life cycle of your invention. You must understand which patents must be maintained, which patents must be abandoned. You must also know the patent and intangible portfolio of your competitors. Because you see, only 3% of patents ever become royalty generating patents. 90% patents never generate royalty. Therefore, one must always keep on evaluating the value of your patent and take a decision whether he wants to maintain the patent, because he is draining out his resources, a lot of resources in maintenance of patent. In the context of a country like India, even within this 3% of patents which are royalty generating, the licensing agreements are mismanaged. As I said, the most important conclusion can be, more than lawyers, it is the managers who require better understanding of tools of intellectual property system so as to face the competition. So we have seen different IP considerations which are relevant in different stages of innovation. The 2016 intellectual new IPR policy claims to establish a framework of strong intellectual property rights. The new IPR policy wants to tap the talent and knowledge of national research laboratories, universities, technology institutions, and other researchers. A strong IP means extending protection, making the rights more extensive. There is too much of emphasis on acquisition of IP. If you read IPR policy and innovation and startup policy, government is emphasizing too much on acquiring IPR. But I think they must also look into the figure which I just presented. Only 3% of patents become revenue generating. During 1990s, a similar movement started. Let me tell you, the CSIR researchers were directed to file patents for their invention. During 1990s, a large number of patent applications were filed by CSIR inventors and patents were claimed. But unfortunately, very few of these could be commercially exploited. And with the help of commercial exploitation, CSIR was not even able to meet the expenses of patent filing. So therefore, we must not emphasize too much on patent acquisition alone. So these are the IP considerations in different stages of innovation. I'm sure somebody will talk about National Innovation and Startup Policy 2019. I will not get into that. So I'll stop here. And kindly mute yourself. Anyway, so this is what I wanted to tell you. That's all. And we can take questions if you have any. Thank you very much.
Sir, I have a question. Can I ask? Yeah.
Yes, please.
Sir, how the royalty amount has been decided? I mean, what is the way the royalty amount has been decided?
Wait. Somebody has to mute. Yes.
Okay,
Yes.
sir, my question was how the royalty amount has been decided.
You kindly look into the innovation and IPR policy. The exact royalty sharing has been mentioned there, or it may be there in the IPR policy of your institution. 40% may go to inventor, 60% may go to the institution, university. So it depends on the IPR policy of your institution. Some broad guidelines have been provided. But you know, the real challenge is not royalty sharing. Can somebody advise Kanchana P to kindly mute herself? Okay, I was saying that the real problem is not sharing of benefit. The real problem starts when the inventor, a professor, a faculty member wants to file patent application. At that stage, you need support because you require assistance of a patent agent. They will charge a lot of money. You'll be paying patent application fees. If you want to file application in many countries, there is an option to file a application called as PCT application. You'll be paying additional fees for that. So a lot of money goes into the process. You need support at that early stage of filing. Once commercialization starts, there will be parties who will come to share the benefits. But the real challenge for an innovator like you and people working in universities is to file the application and meet the expenses at that stage. So all the IICs and all the universities must earmark some fund to encourage the innovators to file applications. Of course, money must be granted after properly vetting the invention, examining the commercial viability of that invention. But yes, some support at that initial stage is required. Anything else?
Sir, myself Shivaram Naik. Not any question, but I would like to give a complimentary. Sir, it is a nice and excellent presentation. You have briefed, elaborate very clearly. Even I had done one management course from IIT Delhi on innovation only, especially strategic innovation. With that course itself, it was not covered. But you have fantastic explanation. At,
Thank you, Shivramji. But somebody can advise Kanchana P to kindly mute himself. Okay, okay. Thank you, Shivram Naikji. Thank you very
Sir,
much.
Rajnish
Anything
sir,
else?
I have one query.
Yes.
Sir, can we get an idea? Means, can we reserve the idea also? The best way to actually copyright an idea or
No copyright for an idea. No copyright for an idea. Ideas are free as air. Only option for you is to keep it a secret. Copyright protects expression of the idea. The language which you use to express the idea is what is protected as literary work. That expression can be in the form of cinema. Cinema can be protected, but the idea behind the cinema, storyline, theme, plot, these are not protected under copyright. But yes, there is a new law coming up, the 2018 guideline of UGC regarding plagiarism. Plagiarism protects expression as well as idea. Plagiarism means passing somebody's idea and expression as your own. So if your ideas are plagiarized, if your facts are plagiarized in the form of publication, you can get the benefit under 2018 regulation of UGC, but no copyright for idea, no copyright for data, no copyright for facts. Copyright subsists only in the expression of the idea. Now, I may add one more thing. You must have experienced that when you start reading a novel, it is really painful to read first 30, 40 pages. Yes. Why? Because during first 30, 40 pages in any novel, the author is introducing the characters and they take a lot of pages to introduce the character. Characters are ideas. So they describe their characters in such detail that character gets embedded in expression. Lifting the character alone is not possible. A part of expression will also be lifted. And there is violation of copyright. You cannot copy Spider-Man. You will have to copy the costume also. You will have to copy the mannerism also. When you are copying mannerism and costume, you are copying expression. So they devote a lot of pages on explaining, detailing the idea. so that idea gets embedded in expression. Let me tell you, when you open a book, whatever you see is expression. And whatever you form here in your mind, the story, characters, these are ideas. Ideas are not protected. Expression is protected under copyright. So if you want to protect your idea, keep it a secret. Anything else?
Hello, sir.
Yes.
Anyone can copy, means the foreigner can copy some other country's person's this IP.
It's a very generic statement. Whether you are talking about books, articles, or you are talking about inventions.
Anything, sir. As example, some logo is there.
Okay. See, as I said, patent protection, let's take invention for example. Patent protection is granted by national office, which is good only in India. So if Indian Patent Office has granted me patent protection, my protection exists only in India. If I don't claim patent in China, for example, then you can manufacture and sell it in China. I cannot stop you because I am not the patent holder there. That is why one has to take a decision and find out all the countries where he may do business tomorrow and claim patent protection in all these countries. This is for patent. For IPs such as copyright and trademark, my offices give protection. My law gives protection in India, right? But then you
Yes, sir.
have an international document. Copyright के लिए you have Berne Convention. Trademark के लिए you have Paris Convention, which obliges all the countries to give same protection to my work or my mark, which I get it in India. You understand my point? So if my book is protected in India, it will also get protection in UK by virtue of a principle called as national treatment principle. Berne Convention says that all the countries must give same protection to his work as he gets it in India. So you get some kind of international protection by virtue of Berne Convention, TRIPS agreement in copyright, in trademark. तो आपका ट्रेडमार्क लोगो कोई कॉपी नहीं कर सकता इंटरनेशनली ऑल्सो बाय वर्च्यू ऑफ पेरिस कन्वेंशन. आपका वर्क, आपका पब्लिश्ड आर्टिकल कोई कहीं कॉपी नहीं कर सकता बाय वर्च्यू ऑफ बर्न कन्वेंशन एंड ट्रिप्स एग्रीमेंट, नेशनल ट्रीटमेंट प्रिंसिपल. लेकिन इन्वेंशंस के कॉन्टेक्स्ट में, पेटेंट के कॉन्टेक्स्ट में, जहां जहां आप पेटेंट प्राप्त करेंगे, only there you can get protection. In countries where you have not filed your application, you are not eligible to get protection, and people are free to copy and sell products there. Is it clear?
Okay, sir. Thank you very much, sir.
Anything else?
So if we want to have a global like acceptation of my patent, if I want my patent to be recognized globally, which possible office could be the best, like WIPO or US or Indian?
Right. First of all, as I've been saying, Gangadeep ji, there is nothing like international patent or global patent, but one thing has been done by a treaty called as Patent Cooperation Treaty of 1978, PCT. PCT allows for international filing of application. Now, you have more than 100 countries which are party to PCT today. Now, instead of filing your application in all these countries, what you can do, you can file your application in the PCT office. And PCT has designated one of the patent offices in India, Delhi Patent Office, as PCT office, PCT receiving office. So you can file your application in Delhi, Patent Office Delhi, designating it as PCT application. Job is done. What you have to do, you have to designate all the countries where you want to claim protection. Fine. Now what PCT does, PCT examines the application to see whether it is new, whether it has got non-obviousness, whether it's got industrial applicability. So it will test the parameters and then send your application to all the countries which have been designated in your application along with a copy of examination report. But ultimately, patent shall be granted by these countries. So there is nothing like international grant of patent, but you have a mechanism of international filing of patent application. So the better way is to file a PCT application. WIPO application nahi hota. WIPO maintains a database of all the granted patents worldwide. That's a different thing, but there is nothing like WIPO application, right? Is it fine,
Thanks, sir.
Gagan?
Thanks so much, sir.
Anything else?
Tirupati Laddu also copyright protection, right? GI tag.
It can have GI. It can have GI. Rasagulla, you must have heard there was a tussle between Odisha and West Bengal. And arguments were presented before the trademark GI office. And the advocate from Odisha, he argued that we have been offering Rasagulla to Lord Jagannath for thousands of years, and then advocate from West Bengal said that it is made up of chena, which means chin, that means broken things cannot be offered to gods. A lot of discussion, and finally it went to West Bengal because there is a method of making it which is unique to that place. Same with Tirupati.
So,
That's it. Nothing else. I can see Rajkiran sir has come. Yes, sir.
I have not come to disturb you, sir. Still, participant can
Sir,
have.
I am done. My time is over. I'm sorry I joined late, but
No issue, sir. No
complete
issue.
it on time. So that's it from me. Thank you very much.
So, thank you, sir. It was a great pleasure to listen to your wise words and learn from it. I take this opportunity to thank you on behalf of the entire institute and participants who were captivated throughout the session. We are grateful to you for giving detailed insights regarding the IPR, its meaning and kinds, and how IPR are important in the field of innovation. The session was very informative and engaging. We sincerely appreciate you for taking out time from your busy schedule to provide us with such valuable information. Thanks a lot, sir.
Thank you.
Once again, thank you, sir. And it's really pleasant listening to you the morning. Such an energetic performance, I can say. People had waked up early morning today because for today only we had started this session at 9 to 11. Thank you so much, sir. We extend warm welcome to you and thank you so much.
Thank you, sir.
Namaskar.
Dear participants, next session will start at 11:15 by Professor Abhijit Singh on the topic entrepreneurial skills and innovation and creativity. Okay, and the test link has been already shared, so I request you all to take the test and complete it by the end of the day, 6 p.m. Okay, and it will be inactive after that. So I also texted yesterday regarding the volunteers for today's validatory function. So I want anyone of you all, any two or three of you all to participate and give a feedback on the program for that. So I request you all to send me a text message in the WhatsApp so that I can coordinate with you. Thank you all. So please join at 11:15 again.